subject to. I'll try to persuade. Let me get. Invoke sections of the Companies Act along with the IBC or PLS. Now the precise query of the court that how this complaint is maintainable for issuance of summons. This is the first basic question which was raised. So first, I will try to satisfy on that issue that how my complaint is maintainable. Now for that purpose, two sections which I like to draw to the kind attention of this honorable court. Now, sir, section 435 is the establishment of the special court under the Companies Act. I will not read the section, I'll just mention in the section. And section 436 is the offense triable by special courts. Now, that includes subsection A, that under the Companies Act, this special court is empowered for triable or all offense which arises under the Companies Act. Now, sir, please, if your honorable court may appreciate that under the Companies Act also there are penal provisions. That is the reason the special court was constituted to try an offense for the offense punishable under the Companies Act, and this court is also empowered to take cognizance for offense other than the Companies Act also. Now, in light of this, since the law doesn't have any embargo, that a case can be filed based on a police report only. This is my case. And the offense which I am alleging in the present. Yes. Pardon? Yes. So section 439 in the honorable court may see. Yes. Subsection 2, 439. No court shall take cognizance of an offence under this act, which is alleged to have been committed by any company or any officer thereof, except on a complaint in writing of the registrar from a shareholder of the company or a person authorized by the central government in that offence. This is the subsection 2 which is written. Now my submission is that no. Yes, sir, I try to satisfy this. So at least my submission may be considered. So I was a director. I have invested in the company for transfer of shares. So I am a member of a company. Therefore, my locus is there to file this complaint. Now, in light of this, there is one judgment of MP High Court. We just only that only one para if honorable court may just try to. The issue in this judgment was this way, that before the NCLT proceedings, there was some suppression of fact. And therefore, based on that fact, a private complaint like this, which we have filed with the special court. Now, in that, if the honorable court may see para 6. So, the complaint which I have alleged and the judgment which I have shown to this honorable court is a non-cognizable offence. Therefore, my submission would be, there's honorable court has argued that why you are not going to the police, or maybe to some. No, I'm posing a query because there was a query that only upon the. Yes. So now, in case of a non-cognizable offence, the only remedy lies like before the magistrate under section 200 CRPC. The magistrate would not empower to try an offence under the Companies Act. But sir, I have invoked Companies because a special act will prevail over the general act. This is the doctrine. Honorable court is aware. So once I have alleging offence under the Companies Act, the special court is empowered to take cognizance of the another offence also. By the registrar or shareholder or any member of a company. Now please see, for that purpose, now in this complaint, para 11, So may read para 8 first, where the same contention was raised that this complaint is not maintainable. Now it has been argued that for the allegation of offence relating to giving false evidence before the court, a special procedure that is to be followed by the court or tribunal prescribed by the body, and it is also mandatory before filing any complaint under section 185 authorized to take cognizance of it was held for the National Company Law Tribunal to have followed the past first on the strength sorry provisions under the section 340 and complaint was required in this step. Now it was also argued the para 9 for the offence alleged to have been committed under section 414 of the Companies Act, no procedure has been prescribed under the Companies Act. However, section 435 specifically provides that procedure prescribed under CRPC shall be applicable to all proceedings before the special court. And if no procedure has been prescribed under the Companies Act, the cognizance taken by is total in respect to the provision of section 430 have been raised error. Now, para 10. Now here the issue is the order of summons which was passed by the Honorable Special Court was not a detailed order. That was the only issue. And this is how. Now please come to para 15 and sorry, para 15. Yes. Para 16. From the bare reading of section 435. Now this is very material for this Honorable Court. It is evident that purpose of providing speedy trial of the offence under the Companies Act, the central government by notification may establish or designate as many special court as necessary, and so the Gwalior has been dedicated. Now, para 19. So far as maintainability of the complaint, now this is what the precise issue is. At the base of the complaint is concerned, section 439(2) of the Companies Act is very much clear. Section 439 lays down as the exception for the courts to take cognizance upon complaint writing made by the registrar, a shareholder, or a member of a company, or a person authorized by the central government that behalf. So my submission is that I am a member of a company, and this is how there is a locus under section 439(2). Thus, it is clear that any of the person mentioned in the section can maintain the complaint, and the complaint respondent being one of the directors. Like here also, I was one of the directors of the accused petitioner could maintain the complaint. Now, this is what my precise submission before this Honorable Court, that since I was a director, based on a fraud document, I was removed. Being a member of a company, this is my how locus comes under section 439(2). Here also the complaint was filed by a director of a company. Now, so far as the contention for the petitioner concerned, while taking cognizance of the matter, the issuing summons has not applied his judicial mind. It concerned, it appears that learned special judge who appears to have taken cognizance under 449 APC, but since it is a private complaint, it was incumbent upon learned to have assigned proper reasons while taking cognizance and mere writing that appropriate counsel. So the Honorable Court has remanded the matter, saying that a reason order has to pass for the issuance of summons, and that is how it was remanded back. So para 15 which para 19 which I cited, that since I am a director and a member of a company, under 439 to my locus is there, and this is how this complaint is also made. Because here also the same contention was taken that a director has filed a complaint under the Companies Act, therefore it is not maintainable for the special court, and this contention has been dead. This is my submission. And as far as once the special act I invoke, which is a non-cognizable offence, even I cannot go to a police authority, nor I can file a complaint to the magistrate, because for the purpose this court for offence triable for non-cognizable can take off. And this is how I am maintainable, being one of the director of a company, and I have been illegally removed based on a fraud documents by passing a resolution. So this is the broad nutshell of the company. So para 19 which I just read out to the Honorable Court. Pardon? So if I am removed under the Directors Act, then I have to go before NCLT that I have been illegally removed, and I have to restore as a, so the resolution which they have passed, I have to challenge before NCLT. So that is a civil remedy. There is a civil remedy. Like in the civil courts, there are two remedies are always one. One is a civil remedy and other is the criminal offense. So today, which I am alleging is an invocation under the Companies Act, because the section which I have cited, I am not bothered to read that section. Based on a court document. Yes, if I want to restore as a director, the resolution which they have passed, because this honorable court cannot restore me as a director, because this honorable under the special. Sir, as a officer, but sir, I have been illegally removed based on a fraud document. Sir, section 118 of the Companies Act for the removal, there is a procedure prescribed. Now that procedure is based on a fraud document. So what I know is that in a company that there are two facets. One is the penal provisions and other, because section 447 if a losses may see, if a company is committing a fraud, there is a penal provision and the sentence is more than 10 years. So today the company has acted that part. This is my submission. No, sir. Registrar can comply before the NCLT direction. Registrar cannot come and arrest. This is why. No, sir. Sir, as a locus, since I was a member of a director of a company, as I just pointed out this judgment, this is how I am maintainable. Otherwise, if I go before NCLT, that is my civil remedy, where I would pray that I as a director I has to be restored on the board and the resolution has to be set aside. But for criminal prosecution, NCLT has no power. And that is how the special court has been made. This is why this submission goes on, subject to consideration. Very
Does Lordship may give you only 5 minutes? I just point out my point. Your Lordships may have a look at it. This certificate itself is erroneous in nature, based on which this application has been filed, and we are withdrawing this certificate now. If your Lordships may have a look at page number 10 for a moment. I'll straight away come to the last 3 paragraphs, sir. Finally, in the third open auction held on, your Lordships have it for a moment, page number 10. No, in the application, sir, page number 10. I believe it's a certificate dated 13th of May 2024. It has a huge Tata logo on the top. I believe mine is annexure 10. Page 47, sir. My apologies, page 47. Sir. Last 3 paragraphs, your Lordships have it for a moment. Finally, in the third auction held on 15th of April 2024, Mr. Jawal Patel successfully bid for 16.71 lakhs for the vehicle Range Rover, meeting the conditions specified in the court order. As a result, Mr. Jawal Patel has been rightfully declared as a successful bidder and is entitled to the possession of the vehicle of Range Rover. This is a certificate. I just completed the remaining paragraph, and I'll point out that this certificate is not a sales certificate. It's merely a confirmation that he is an successful auction bidder, sir. In compliance with the order court order, Mr. Jawal Patel is required to submit a 5-year bank guarantee of the value of which the said car is sold. We hereby confirm our commitment to the providing the necessary surety letter for the vehicle, Land Rover, Range Rover, car number so and so to Mr. Jawal Patel upon fulfillment of the court condition. This apparently is wrong. The earlier order is different. I'll take your Lordship to that order also. In the last 2 lines, we trust that this certificate adequately attests the successful completion of bidding process and the rightful ownership of vehicle Range Rover by Mr. Jawal Patel. Now, if your Lordships may have a look at the earlier order passed by this honorable court, that is on page number 28, the operating part I want to point out, sir. The operating part in paragraph 2. We are concerned with paragraph 2 because paragraph 1 has stands complied with. It is paragraph 2 that is not complied with. The applicant shall submit 5 years bank guarantee of the value of which the said car is sold within 15 days of selling the said car before this court. My submission is that car is not sold yet. Car is yet to be sold. What has happened is a certificate has been issued showing him a successful bidder. Unfortunately, that certificate contains a paragraph which is apparently erroneous, as observed by this honorable court rightly on on 7/11/2024. Your Lordships may have a look at the last order passed by this Honorable Court 17/11/2024. In the last paragraph, your Lordships have rightly read that we have misinterpreted and misread this order and passed this certificate. So today I can't go ahead with this sale. The sale is not concluded yet. It's only a certificate giving confirming that he is a successful bidder. But it is a certificate which is erroneous in nature. I will have to withdraw that certificate, move and cancel this process itself. Therefore, I have given an affidavit right now to the Honorable Court. Your Lordships may have a look at that affidavit for a moment. That by virtue of that affidavit, I am now cancelling that certificate itself, my lords. I can't proceed further. It's on the basis of false wrong premises. Page 48. It's a confirmation that we are wrong, sir. We are wrong. But on a further reading, we realize that we can't proceed further because ultimately the certificate itself, based on which this application is filed, is wrong. This application is misconceived on two parts, sir. One, it is premature in nature. Ultimately, I was supposed to come after the sale is done. Your Lordships may have a look at the order once again, passed by trial court, by this Honorable Court. That is on 19/1. Within 15 days of selling the said car before this court, the vehicle has not been sold as of yet. This is a premature application state away before this Honorable Court, and based on certificate which is apparently erroneous. Today, sir, if I proceed further, I will be committing contempt. There's a reason for it. The order says that I have to give the certificate 15 days after the sale. Vehicle is not being sold yet. If I give the certificate, if I give the bank guarantee today, it would mean that amount. Yes, we can. For that, we clarified that with the purchaser. Today, we are before the Honorable Court with a folded hand. We'll have to withdraw this application. It's misconceived. Your Lordships may. Yes. Which process, sir? No, sir. Yes. It has practically, the vehicle is practically destroyed completely, sir. Today, as of today, 50 lakh નું vehicle છે, sir, 5 lakh નું નથી રહી. એટલી ખરાબ હાલત છે. Sir, the problem is this wise. The company doesn't have a policy. What has happened is this the concerned officer has made a mistake by filing this application itself. The company doesn't have a policy of giving bank guarantee because we are already in the severe loss for this vehicle is concerned. Yes, I quite see. Sir, my submission is this one. We do not. Sir, I do not want to proceed the same. That's what I want. I want to cancel this. It was misconceived, as rightly observed by the Honorable. This application is misconceived. Earlier applications I may file kari હતી. Emma sir, earlier application your Lordships may have a look at the last second paragraph. 15 days of sale, I want to do it. Now, after that application, I give a share certificate. Sorry, a certificate. આજે ઓર્ડર બેસિસ ઉપર ઓપ્શન કર્યું. ઓપ્શનમાં મેં સર્ટિફિકેટ જે આપી ફોટો છે. Yes. Sir, આપનો ઓર્ડર સર આપો ઉપર. એમાં Yes. 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 No, I'm sorry. Sir, but I do not want to proceed with the sale. That's my request. Cost, sir. I'm inviting next. Your Lordship will dismiss it with costs.
ગુજરાત આતંકવાદ અને સંગઠિત અપરાધ નિયંત્રણ ગુજસીટોક અધિનિયમ 2015 ની કલમ 3.2.3.4 મુજબના ગુના સબબ તારીખ 29/10/2020 ના રોજ અમોની અટક કરેલ અને જ્યુડિશિયલ કસ્ટડીમાં લઈને જેલ હવાલે કરેલ છે. જેથી રેગ્યુલર જામીન ઉપર મુક્ત થવા માટે હાલની અરજી કરવામાં આવેલી છે. નામદાર આપણે 2020 થી જ્યુડિશિયલ કસ્ટડીમાં છે. પેરેગ્રાફ નંબર 2 છે. આમાં સાહેબ 14 પેરેટી છે. તો ટોટલ એફઆઈઆર મુજબ 20 આરોપીઓ છે, જે પૈકી હનીફ ખાન ઉર્ફે કાળો મુન્નો છે, જે મરણ પામે છે. એટલે સાહેબ એમાંથી 19, એમાંથી 14 જણાને સાહેબ પેરેટી ઉપર છોડવામાં આવે છે, જે પૈકી નંબર 1 બિલ્કિસ બાનુ, હનીફ ખાન જજ મલિકને નામદાર સુપ્રીમ કોર્ટ દ્વારા ફોજદારી પરચુરણ અરજી નંબર 398/23 થી તારીખ 17/3/2023 ના રોજ જામીન પર મુક્ત કરવામાં આવેલ છે. નંબર 2 સબીર હુસૈન મિયા સાહેબ ઇમામ મિયા સૈયદ નામદાર સુપ્રીમ કોર્ટ દ્વારા ફોજદારી પરચુરણ અરજી નંબર 185/2023 થી 9/10/23 ના રોજ રેગ્યુલર જામીન પર મુક્ત કરવામાં આવેલ છે. નંબર 3 જસવંત ઉર્ફે જસો કાળુભાઈ સોયાને તારીખ 2/11/23 ના રોજ ફોજદારી પરચુરણ અરજી નંબર 39/59/23 થી રેગ્યુલર જામીન પર નામદાર સેશન્સ કોર્ટ દ્વારા રેગ્યુલર જામીન પર મુક્ત કરવામાં આવેલ છે. નંબર 4 મહિપાલસિંહ ઉર્ફે કાળુભા બટુકસિંહ ઝાલાને રેગ્યુલર જામીન પર ફોજદારી પરચુરણ અરજી નંબર 41/61/23 થી નામદાર સેશન્સ કોર્ટ દ્વારા 10/11/2023 ના રોજ રેગ્યુલર જામીન પર મુક્ત કરવામાં આવેલ છે. નંબર 5 હજરત ખાન અનવર ખાન જત મલિક ને કોપા નંબર 43/13/2023 થી તારીખ 1/12/2023 ના રોજ રેગ્યુલર જામીન પર મુક્ત કરવામાં આવેલ છે. નંબર 6 વસીમ ખાન બિસ્મિલ્લા ખાન જત મલિક ફોજદારી પરચુરણ અરજી નંબર 44/02/2023 થી 18/12/2023 ના રોજ રેગ્યુલર જામીન પર મુક્ત કરવામાં આવેલ છે. સાહેબ વસીમ બિસ્મિલ્લા ખાન છે, he is also abated. એનું એ પણ મરણ ગયેલ છે એક્સિડન્ટ. નંબર 7 સિકંદર ખાન અનવર ખાન જત મલિક ફોજદારી પરચુરણ અરજી નંબર 45/67/2023 ના કામે તારીખ 4/1/2024 ના રોજ રેગ્યુલર જામીન પર મુક્ત કરવામાં આવેલ છે. નંબર 8 મોહમ્મદ ખાન રાજબા હુસૈન ખાન જત મલિકને ફોજદારી પરચુરણ અરજી નંબર 46/24/2023 ના કામે તારીખ 5/1/2024 ના રોજ રેગ્યુલર જામીન પર મુક્ત કરવામાં આવેલ છે. નંબર 9 રોમિસ ખાન મોહમ્મદ ખાન જત મલિક ને કોપા નંબર 12/21/2024 ના કામે નામદાર હાઈકોર્ટ દ્વારા 20/2/2024 ના રોજ રેગ્યુલર જામીન પર મુક્ત કરવામાં આવેલ છે. નંબર 10 મોહમ્મદ ખાન માલાજી જત મલિક ને ફોજદારી પરચુરણ અરજી નંબર 26/23 નામદાર અમારી અગાઉ છે ને એક જામીન અરજી જે રિજેક્ટ કરવામાં આવી છે. જી નામદાર, પછી અમે હાઈકોર્ટમાં 6 મહિનાના પીરિયડ સુધી વિડ્રો કરેલી હતી ને કોઈ લોયરે, તો એમને 6 મહિના પછી દાખલ કરવાની હતી અને દાખલ કરેલી અને પછી એના ઓર્ડર્સ પણ રાખેલા. જેટલી જામીન અરજીઓ અમારા દ્વારા કરવામાં આવેલી એ રિજેક્ટ કરવામાં આવી. એ વખતે સાહેબ આટલી પેરિટી ને બધું નહોતું. જી નામદાર. ઓગસ્ટમાં સાહેબ. પછી નામદાર આમાં સાહેબ બધાએ પહેલી વાર બીજી વાર કહી દીધું એવું નથી. સમય જતા બધાએ બીજી ત્રીજી વાર કરેલી નહીં નામદાર. વચમાં જે અમુક થોડો પીરિયડ હતો એની અંદર અમારે સાહેબ ઘરના સંજોગો એવા હતા, અમે હાજર નહોતા થઈ શક્યા. ત્યારબાદ અમે પોલીસ સમક્ષ હાજર થયા અને એમને એવું કીધું કે ફરાર થયા, અમે પકડ્યા ના સાહેબ. એમાં એટલે સાહેબ એક ઓર્ડરનું નામદાર કોર્ટને હમણાંનો જ છે, સરી પલ્લા રખા ડફેર. આ 14 પેરીટી તો કરી સાહેબ. એ સિવાય 15મી પેરીટી હમણાં નામદાર કોર્ટે સરી પલ્લા રખા ડફેરને જામીન પર મુક્ત કરેલ છે. નામદાર હાઈકોર્ટ જે ઓર્ડર આપ નામદારને રજૂ કરું. જી નામદાર. અને ભાગીને પણ 307
કમિટ કર્યો ત્યાં લખતર પોલીસ સ્ટેશન. નામદાર કોર્ટે એ વસ્તુને અનુસંધાને પણ જામીન આપેલા છે. જી નામદાર, અગાઉ એની પણ રિજેક્ટ થઈ ગઈ. તેમ છતાંય આટલી બધી પેરિટી છે સાહેબ, એના અનુસંધાને આ હાલના અરજદારનો રોલ સેમ હોય તો નામદાર કોર્ટે એને પણ જામીન આપેલા છે. જે ઓર્ડર નામદાર કોર્ટને રજૂ કરું. આ ફ્રેશ ઓર્ડર છે સાહેબ, હમણાંનો ડિસેમ્બરનો. સોરી, એમાં સાહેબ પેરેગ્રાફ નંબર 4 હું વાંચું છું. પર કોન્ટ્રા learned APP has opposed the present applicant for grant of regular bail, contending the present applicant will be on temporary bail, had absconded, and during the said period he again commit an offence punishable under section 307, paragraph number 4 Your Honor, of the Indian Penal Code. Moreover, the applicant had also જી આની તો કરું છું સાહેબ, આની તો કરું છું, પણ એ સિવાયના બીજા 14 ઓર્ડર સાહેબ. વસીમ બિસ્મિલ્લા ખાન હતો ને, એની ઉપર he is a main member of syndicate. પછી નામદાર કોર્ટે એને પણ જામીન આપ્યા છે. he is also absconded. એટલે આવું પ્રથમ કિસ્સામાં થાય છે સાહેબ, એવું નથી. સાહેબ, આ પેરેગ્રાફ હું આગળ પણ વાંચું છું કે નામદાર હાઈકોર્ટે જે વસ્તુ ધ્યાને લીધી છે અને તેમ છતાં પણ રેગ્યુલર બેલને ગ્રાન્ટ કરેલી છે. Moreover, the applicant had also assaulted the police personnel who had gone to arrest him. The other co-accused who have been considered for grant of bail either by the Honorable Apex Court or by this court, to the role which is not equal to the role attributed to the present applicant. Learned APP has therefore submitted the looking to the nature of offence. જી નામદાર, જો 14 પેરીની નામદાર જે અગાઉ નામદારે છોડેલા છે, હાલનો જે આ ઓર્ડર છે, હમણાં જે રિસન્ટ ઓર્ડર નામદારે કરેલો છે, તે 307 એમાં પણ સાહેબ 3 વર્ષ આ જે હાઈકોર્ટમાં જે ઓર્ડર મૂકેલો છે ને સાહેબ, જે લાસ્ટ નામદાર કોર્ટને મેં રજૂ કર્યો અત્યારે, એની અંદર પેરેગ્રાફ નંબર 5 માં લાઈન નંબર 7 એમાં 3 વર્ષ સુધી તો એ આરોપી ફરાર રહેલો. તેમ છતાં એ 307 કરે છે, તેમ છતાં પણ નામદાર હાઈકોર્ટ એને રેગ્યુલર જામીન પર મૂકે.
In line is the order of the Honorable High Court, Justice Stokes. Because the all contention has been dealt with, the parity aspect also dealt with, not this one, but the other parity aspects, including the order passed by the Honorable Apex Court. That has also discussed by the Honorable Gujarat High Court. Page number 6 is the order of the Honorable Gujarat High Court, passed in PRMA number 12693 of 20. જે સાહેબ આપ કહેતા હતા 9/8/2024 સર ફ્રીઝિંગ નથી એમને કર્યું, તરત જ સાહેબ આપ એપ્લિકેશન પછી તરત આઈ થિંક ના ઓનરેબલ સુપ્રીમ કોર્ટના ઓર્ડર છે. આઈ થિંક ત્રીજો કે ચોથો ઓર્ડર છે. Successively.
જી નામદાર નામદાર
એ સાહેબ આપ્યું મારામાંથી કટ કર્યું. પેજ નંબર 2 માં સાહેબ પેરા 3.1 એમાં સિન્ડિકેટનો ઓફેન્સીસ નામદાર ગુજરાત હાઈકોર્ટે ડિસ્કસ કર્યા. પેજ નંબર 3 પેરા 4 કેટલી એપ્લિકેશન્સ નામદાર ગુજરાત હાઈકોર્ટમાં કરેલી છે એ લખ્યું. પછી પેજ નંબર 5 પેરા 7 Learned advocate the applicant has argued that case of the present applicant deserves consideration as to whether are granted regularly in this connection. It is pertinent to observe that the FX was granted regularly to two co-accused persons, of which one is already accused and other co-accused were released by the FX court. The other three co-accused are released on regular basis by the coordinate bench of this court only on the ground of pairing. However, against the present applicant, there are serious changes. Paragraph. It has also come on record that when the present applicant was on temporary basis, he absconded and was involved in offense of similar nature. Thus, the applicant appears to be habitual of considering the gravity of the offense. The rule as presented and the applicant being habitual of offense. Court is not different exercise. Broadly, આરોપીની સામે કેસ એવો હતો. નવેમ્બર 20 ની અંદર આરોપી અરેસ્ટ થયો. 2 વર્ષ સુધી જેલમાં રહ્યો. સપ્ટેમ્બર 22 પછી એ 1 વર્ષ એબ્સ્કોન્ડિંગ રહ્યો અને એબ્સ્કોન્ડિંગ રહ્યો એમાં થેફ્ટનો જેણે ઓફેન્સ કર્યો અને પછી પાછો 1 વર્ષની જેલમાં છે. એટલે ઇન્કાર્સરેશન 3 વર્ષનું થાય છે. આની પહેલા એક કો એક્યુઝે આપ નામદાર કોર્ટમાં બેલ એપ્લિકેશન ફાઇલ કરેલું જે એબ્સ્કોન્ડિંગ રહેલો 2 વર્ષની અંદર હતો. 1 વર્ષ એબ્સ્કોન્ડિંગ અને ડ્યુરિંગ ધી કોર્સ ઓફ હિઝ એબ્સ્કોન્ડન્સ એને 307 નો ઓફેન્સ કરેલો. સાહેબ આપને યાદ હોય તો એક પોલીસ ઓફિસર્સને નખત્રાણાવાળો. હવે ઓન ફેસ ઓફ ઇટ આઈ મે આસિસ્ટ ટુ ધી ઓનરેબલ કોર્ટ જે એ ઓફેન્સ હતો that was grave and looking to the gravity the honorable court has rejected that application. That applicant appeared before the honorable appellate court, the honorable Gujarat High Court. The honorable Gujarat High Court has taken into consideration that aspect and enlarged the applicant. The theme line, theme line is the order of the honorable Gujarat High Court rejecting the bail application.
નામદાર મારું ખાલી કહેવાનું એટલું જ છે. 54 નામદાર આયોગનું જે છે પેરેગ્રાફ નંબર જી નામદાર પણ જી નામદાર બિલ્કિસ બાનુ એન્ડ સબીર હુસૈન ઇમામ મિયા શેર those are released by the નામદાર એવું નથી કે અમે બધાએ પહેલી બીજી ત્રીજી વાર સાહેબ નામદાર કોર્ટ પાસે કરેલું એમાં પણ હાલનો ઓર્ડર નામદારને મેં જે રજૂ કર્યો એ 3 વર્ષ સુધી સાહેબ ફરાર રહે છે અને 307 જેવો હિનિયસ ઓફેન્સ કરે છે. તેમ છતાંય નામદાર હાઈકોર્ટ એને નજરઅંદાજ કરીને તેમ છતાં પણ એને બેલ આપે. નામદાર હાલના તબક્કે એને આ કામે સાહેબ એને તેમ છતાં પણ જામીન આપવામાં આવે છે. સાહેબ બીજું એફિડેવિટમાં જોવા જઈએ તો અમારા ઉપર ખાલી 4 ગુના બતાવે છે. ત્યાં સાહેબ 120 ગુના, ત્યાં 4 ગુના. સાહેબ જે આખી સિન્ડિકેટ છે એની ઉપર 120 ગુના. હવે જે 2019 પછીના જે ગુના કે છે એની અંદર સાહેબ અમારી ઉપર તો 4 ફાઇલ થયેલા. એમાં સાહેબ અમે કદાચ એક કર્યો ને તેમ છતાં પોલીસ બીજા 4 નાખી દે તો સાહેબ 5 પણ થઈ જાય.
અરે પાંચ.
That is
એ તો આપણે
possibility.
પેલા પાંચ એટલે ટોટલ નવ છે.
જી નામદાર.
તો તમે સાચું બોલ્યા.
એટલે હું એક બાર 2019 પછી ના જી નામદાર. એટલે આવું પ્રથમ તબક્કે એના અંદર પહેલી જ વાર થતું હોય એવું નથી કે આવી પ્રકારની બેલ હું પહેલી વાર ફાઇલ કરું એવું નથી. એટલે નામદાર કોર્ટ જે તમને શરત ફરમાવશે એનું પાલન કરે. નહીં તો સાહેબ અમને પ્રી ટ્રાયલ પનિશમેન્ટ થાય. ગુનાની સાહેબ જોગવાઈ જોવા જાવ તો 5 વર્ષની સજા.
Change of circumstances will be recent order. એ ડિસેમ્બર 2024. નામદાર ગુજરાત હાઈકોર્ટે જે એપ્લિકેશન રિજેક્ટ કરી છે એ ઓગસ્ટ 2024. ના સાહેબ, કારણ કે જૂનું છે, આ તો રિસન્ટ ઓર્ડર જસ્ટ 11/12. એટલે હા, હું સમજી ગયો.
સાહેબ અમે ગરીબ અને ખેડૂત માણસ છીએ એવા ધની અને વૈભવશાળી જીવન જીવતા હોય એવું નથી. નહીં એટલે સાહેબ એવું નથી કે અમે પૈસા ખવડાવીને સાહેબ પોલીસને
રિજેક્ટ કરેલો હોય એવું. એ સાહેબ એટલા માટે નહીં હોય કારણ કે શરીફ પલ્લા રખાની હમણાં જ આપણી ત્યાં એ મેટર ચાલે છે અને પછી રિજેક્ટ કર્યું આપ સાહેબે, એટલે એ પછી ગુજરાત હાઈકોર્ટમાં જઈને આવે. અને મેક્સિમમ પનિશમેન્ટ એનો સાહેબ મેક્સિમમ લખાયેલું છે. ઠીક છે. Words for which the minimum sentence is 5 years. Minimum. No, minimum. Correct.
સાહેબ એમને અટક કર્યા પછી સાહેબ બીઝેડ ફાઇનાન્સ સર્વિસ ના નામે બનાવેલી વેબસાઇટ એના આંકડા મુજબ 11,232 રોકાણકારો કુલ રૂપિયા 422 કરોડ 96,41,575 રૂપિયા મહિને 3% વ્યાજ આપીને ઉઘરાયેલા. અમુક રોકાણકારોને દર મહિને વ્યાજ આપતા હતા. એ પૂછપરછ દરમિયાન એવી હકીકત જણાઈ આવી કે અમુક રોકાણકારોને અમુક ટકા લેખે નાણાં પરત આપતા હતા અને 12 મહિને અને 24 મહિને જે સ્કીમમાં રોકેલા હોય એ વ્યાજ ગણતરી સાથે રોકડા આપતા હતા. હવે કુલ કેટલા રોકાણકારોને વ્યાજની રકમ રોકડામાં આપી, કેટલાને એ રોકડા પૈસા ક્યાંથી લાયા અને એ રોકાણકારને વ્યાજની રોકાણનો હિસાબ શું, કયા દરથી આપીને કેટલા રૂપિયા આપ્યા, એ સાહેબ તપાસ વેબસાઇટના આધારે કરવાની બાકી છે. કારણ કે કેશનું અગાઉના રિમાન્ડમાં આવતું નહોતું સાહેબ. મેં રિમાન્ડ હજી રિપીટેડ એકય નહીં સાહેબ, એક પણ નહીં. એટલે જ મેં કહ્યું સાહેબ અગાઉના રિમાન્ડનું જે ગ્રાઉન્ડ હતું ને એમાં આ રોકડ કેશનું કોઈ ગ્રાઉન્ડ નહોતું સાહેબ. ખાલી કેશના મારી પાસે એ વખતે 52 કરોડ રૂપિયા કે 55 કરોડ રૂપિયા ઓફિસમાંથી જે ચોપડા મળ્યા ને એટલું જ હતું. અત્યારે એની વાત એના કરતા વિપરીત ઇન્વેસ્ટિગેશનમાં બીજું ગ્રાઉન્ડ એવું સાહેબ, રોકાણકારોને સ્કીમમાં સાહેબ એજન્ટોના નીચે 5 લેવલના એજન્ટો નક્કી થયેલા છે. 1%, અડધો ટકો, 1.25% અને 0.10% અને 0.5% એ કમિશન આપતા હતા. એ રોકડાથી કેશથી આપતા હતા. એટલે કુલ કેટલું કમિશન આપતા હતા એના હિસાબો કબજે કરવા. હવે જે આ 5 લેયર છે ને એ વેબસાઇટ ઉપરથી મળેલું છે. ફર્સ્ટ લેયરને 1%, સેકન્ડ વાળાને 0.50, પછી 0.25, 0.10 અને 0.5. એટલે સાહેબ આ 5 લેયર વાળાના જે કમિશન આપ્યા એ એમના વેબસાઇટ ઉપરથી માહિતી મળી. આ એજન્ટોને બનાવેલા એ કેટલા એજન્ટ બનાયા, એવા કેટલા આગળના કેટલા લેવલ છે એ તપાસ કરવાની બાકી છે. પછી સાહેબ આ જે હિસાબો રાખતા હતા એ લેપટોપમાં ટેલીમાં હિસાબ રાખતા હતા. એ લેપટોપ હજી કબજે કરવાનું બાકી છે. જે આ માહિતી જે મળી ઓફિસમાંથી મળેલી માહિતીના લેપટોપ મુજબ સાહેબ હકીકત મળી ગઈ સાહેબ. પછી સાહેબ એમને રિમાન્ડ ઉપર મળ્યા પછી સાહેબ રોકાણકારોના રૂપિયા સ્ટેમ્પ લીધેલા 300ના સ્ટેમ્પ પેપર સાહેબ ફેન્કિંગ કરેલા એગ્રીમેન્ટ બનાવતા હતા. તપાસ દરમિયાન એવું જણાવ્યું સાહેબ કે સ્ટેમ્પ મોડાસા નાગરિક સહકારી બેંક અને સર્વોદય નાગરિક સહકારી બેંક મોડાસાથી ખરીદેલા. એ ટોટલ 12,560 સ્ટેમ્પ માહિતી બેંક પાસેથી માહિતી મંગાવતા ખરીદાયેલા છે. અને વેબસાઇટ મુજબ 11,232 રોકાણકારોની એન્ટ્રી છે સાહેબ. તો કુલ 1,286 એની એન્ટ્રી નથી રોકાણકારોની. આ રોકાણકારોના કેટલા નાણાં છે, કોણ રોકાણકાર છે, 1,286 એમના નામ સરનામા બધું એમની પાસેથી મેળવવાનું બાકી.
16, paragraph 24. In view of the aforesaid factual aspects, the plaintiff humbly prays as under. A. The Honorable Court may be pleased to pass a preliminary decree that the plaintiff has a share in the suit property or other share in the immovable properties as mentioned in schedule number 1 of the plea. I'll take the Honorable Court to schedule 1 a bit later. B. The Honorable Court may be pleased to pass a preliminary decree that the plaintiff is entitled to separate partition and allotment of her share in the immovable property mentioned in schedule 1. C. The Honorable Court may be pleased to declare that the defendants number 1 and 2 have no right, title and interest to execute the registered seal deed bearing number so-and-so dated so-and-so in favor of the defendant number 13 to the extent of plaintiff's share in the suit property mentioned in so-and-so and the ancillary relief. Now, I would request your lordships to come to the schedule on page 19, schedule 1. May I read? Property being part and parcel of non-agricultural land, lying and situate in the registration district district Ahmedabad 4, Pardi, Taluka Vijalpur, village Moje, Jodhpur, town planning scheme number 4, of final plot number 10, new survey number so and so, head measuring so and so, meters having old number so and so, so and so, so and so. The boundaries, I am not taking the honorable court to that. Page 20 would reflect the date on which the suit was filed, that is 12th of February 2024. The cause of action for filing of the suit is at page 14, paragraph 21. Essentially, the prayers made in both the suits are, the common prayers are for partition of the property. There are two properties situated virtually in the same locality, in the same, the town planning scheme number differs, the final plot number differs, the measurement differs, the taluka remains the same, the district remains the same, the nomenclature differs. May I read on page 14, paragraph 21? That is the second suit.
One suit stay in press.
We don't want any stay of all the proceedings. We want stay of the second suit. There is a reason behind it. Suit of stay of the proceedings. The reason being, there are two suits filed, 76 and 92. The difficulty here, the difficulty on this side is that is during the pendency. The reason being, the prayer has been made. The reason behind it is that so far as the second suit is concerned, ordinarily, as far as the proceedings are concerned, not in order to see that it does not become an academic issue. We have filed application. I might see we have filed application. 24 would be as good as an administrative decision. As good as an administrative decision. If the honorable court is of the view that so far as the parties are concerned, so far as the list between the before the court is concerned, yes, the first 76 is pending before the learned 7th additional chief judicial magistrate. The second, that is 92 of 2024, is pending before the learned 5th additional chief judicial magistrate. Now, just a comparison on the parties, so far as the parties are concerned, the first suit has 13 defendants because there the property was transferred in favor of defendant number 13. But I was requesting the honorable court to just have a look at the cause of action. The cause of action remains the same. The first suit is filed on 12th of February. The second suit is filed on 28th of February. It is not that there is any difference in the cause of action. Page 21, I was requesting the honorable court. I'm sorry, page 14, paragraph 21. That is the cause of action mentioned in the first suit. I may read. Page 14, paragraph 21. Paragraph 21. It is most respectfully submitted that the cause of action to file the present suit has arisen on various dates and circumstances as mentioned above. More particularly, when the suit property was originally owned by the deceased so and so, and when after the death of so and so, names of the legal heirs were mutated in the revenue records of the suit property and also dependent number so and so, being the heirs of so and so. Their names were also recorded in the revenue record of the suit property. It is submitted that the present dependent number 1 and 2, along with other defendants, had maliciously transferred the suit property in favor of the defendant number 13 by virtue of the registered sale date. This is where the cause of action differs in the two suits. Otherwise, the cause of action remains the same. So, yes, page 41 is the plaint of the second suit, 92 of 2024. There, the Honorable Court would find that there are only 12 defendants because there is no transfer of property taking place. May I invite the attention of the Honorable Court to page 44, paragraph 4. This paragraph 4 remains constant in both the suits. It remains paragraph 4 in the earlier suit also. This is what it mentions. It is most respectfully submitted that other than the present suit property mentioned here in above in the present suit, there are other properties being vested in the present defendants as ancestral properties being originally owned by so and so. It is submitted that the present plaintiff reserves right to file separate suit for the said property after attaining the revenue records for the said properties from the concerned authorities. Now this remains the same. Paragraph 4. In the first suit at page 5, same instance, the defendants are the same. Their case basically is the same. Their case is that the properties are ancestral properties. The defendants, the property being ancestral property, the daughter would be entitled to have a share in it. No difficulty in laws. So far as deciding the litigation on its merits is the case, Lords, I am not entering into whether the whether the suit is maintainable, there is any right. I'm not taking the Honorable Court to that, because ultimately the parties will have to lead the evidence. Page 21, the Honorable Court will have noticed the cause of action in the first suit. The same paragraph 21 is on page 54 in the second suit, minus the transfer of the property in favor of the defendant number 13. So para 4 in both the suits remains the same. Cause of action remains the same. Para 21 remains the same. How, under what circumstances the suit came to be filed. In the first suit, as I pointed out, on 12th of February, the suit was filed, keeping this caveat that I am in the process of getting the revenue records in respect of other properties, and I would like to file a fresh other suit. The second suit is filed. Now, so far as the second suit is concerned, page 58 may be seen, the schedule of the property in the second suit of 92. The earlier suit, 76, was in respect of final plot number 10, town planning scheme number 4, Paladi, and survey number 539. This is town planning scheme number 5, survey number 273, and final plot number 205. At page 58, it says scheduled as registration district sub-district Ahmedabad 4, Taluka Vejalpur, village Jodhpur, revenue and survey number so-and-so, total head measuring so-and-so, town planning scheme number so-and-so, comprising of so-and-so, of NLN along with the construction of so-and-so. Virtually all the entire crux of both the suits is the same. And now in that background, if the Honorable Court would have a look at the prayers made in the second suit that starts from page 55, paragraph 24. And sir. That is injunction application of the second suit. 73 is the injunction application. The plaint of the first suit is at page 1. The plaint of the second suit is at page 41. and 73, the Honorable Court would, that is a part and parcel of the Exhibit 5 application that starts from page 60. Properties, the survey numbers are different. I may once again, if the Honorable Court may just have a look at the schedule of both the properties. 19 vis-a-vis page 58. 19 in the first suit and 58 in the second suit. So property remains, obviously the properties would differ. But then both are non-agricultural land. First is final plot number 10. The second is final plot number 205. First is a part of town planning scheme number 4. The second is town planning scheme number 5. First is survey number 539 and the second is survey number 270. So far as the only difference between the two is that the first property has been sold in favor of defendant number 13 of that suit. The second property has not been sold. Now, therefore, the request to the Honorable Court is that when the suit is essentially between the same parties, essentially when the cause of action is the same, for her to file the suit, the prayers are identical in both the suit. The averments are virtually the same. Prayer same, and it is filed in close proximity. Therefore, the only request is that if the suit of the second suit is transferred to the first, along with the first suit, before the learned 7th court, there is an additional addendum to this. The parties are at daggers drawn. The husband and the wife are fighting the litigations. The husband has filed divorce proceedings. Those proceedings are pending. 24 application is decided. The matter is pending. But so far as the wife is concerned, the wife has filed domestic violence proceedings, which are also pending before the learned 7th court. It will not have any nexus. The parties would be different. The nature of evidence would be different. But the request to the Honorable Court is that there has to be appreciation of evidence in both the suits by a common judicial mind. It may not happen that before the one court, the suit of 76 of 2024, there would be, I will have to lead separate evidence for both the suits. I'll have to attend both the suits separately before different courts. And in that background, if the Honorable Court may just have a look at page 74. The reason why there is a request for stay of the suit.
Yes, sir, I'm answering for that. Sir, Emma, typically, the commission being made by the friend is that the first suit, the suit that is 76 of 24. The plaint of 76/24 may be that is annexed by page number 1. We said there are 13 defendants in that. However, the structure, the frame of the present application under section 24, the frame is defective. That defendant number 13, Rathalanjali Sky, is never being made party to this section 24. He is not before this honorable court. He is not even party to that. Now, both suits which are being filed are to the fact that the para number 4 of my earlier suit provides for the fact that we are in process of collecting necessary material information for the other property, and we have reserved our right. Urgency of filing the earlier suit was that we got to know that they had already transferred the property to third party. That third party was joined in the earlier suit. So parties are different. Points of adjudication are different. However, the second suit follows the way that આ જે property છે હવે એમાં તો તમે વેચી દીધી છે એમાં મારું cancellation of sale deed I am seeking the relief of cancellation of sale અને બીજો જે દાવો છે એમાં I am seeking simplicity of partition કે મને મારા ભાગ પૂછું હવે સર બીજો parties are there but the relief section 24 my only point of concern today before this honorable court is the relief which they are seeking before this honorable court. I'll seek liberty to read the reliefs which they are praying for. 14, sir, para number 14 was the relief. Prayer clause. Prayer 1, your honorable will please to admit the present. Now prayer 2, sir. Your honorable court will please to transfer the special civil suit 92 of 24 pending before the honorable court of 7th additional senior civil judge so Ahmedabad to court of 5th additional senior civil judge where the special civil suit 76 of 24 filed by the present respondent hearing is pending for execution. No vis-a-vis prayer is being sought. Why they want, with utmost respect and consciousness of my state of mind, I am making this submission before this honorable court. Why this relief? Why they want that this should go there and the general trend in the section 24 petitions are that suits are pending before two separate courts. आप नामदार साहब कोई पर एक कोर्ट में आप नामदार साहब कोई पर एक कोर्ट में करो, that is the relief and that is the standard practice of the relief that I mean is the relief मंगाए. They cannot choose anything. They are not. They have no liberty to choose the court. However, this relief we suggest something with all consciousness. I am making this submission. Why this relief? Now, sir, relief we have said Joshua, sir, admitted that abandoned दावाओं if being adjudicated by a same judicial officer, विरोधाभासी judgment नहीं आवे, but relief 3 months हम कहते कि both the suits may be transferred to any other court, not even 5, not even 7. I cannot object to it. But the relief 2, certainly I have objections. Can get avi relief તમે માંગો છો what they want to portray before the honorable. There has to be vis-a-vis relief. That vis-a-vis relief is not there. And thirdly, sir, prayer 4. Pending admission final disposal of the applicant, honorable court will please to the further proceeding of special civil to 92 of 24. Sir, that is rejected, but why only 92 or 24 they want a stay of the proceeding? I'm showing that malicious conduct. I'm showing the malicious conduct of this applicant. But sir, only concern if my learned friend would have come with the relief stating with para 14 subclause 3 relief or I would have simply endorsed no objection. But the relief 14 subclause 2, that is something that requires it.
खाली एक वस्तु, since Malachites are attributed only one aspect, how the proceedings before the learned trial court is being attended to by the plaintiff. Please see page 74. Please compare the dates on which those matters were listed. So far as 76 is concerned, they keep on getting adjourned for longer date. Please compare the two dates. The first suit was filed on 12th of February 2024 and the dates are on page 76. So first is 12th of February, then 5 March, 27 March, 22 4, 4 5, 26 6, 6 7, 25 7, 23 8 and all. Now the 78, page 78 is the cause, is the case status of the second suit, and the dates may be seen on page 80. 29 February, 1 April, and thereafter 2nd April, 7th May, 8th May, 9 July, 14th August, 21 9, 27 9, 4 10. And my application under 711 is pending before virtually both the courts.
Both the matters.
They are not being taken up together.
711 application, I had already filed my written arguments to order 711 application.
So it can't be that so far as 76 is concerned, it problem. Yes.